Allah. Does it original?
Okay, in Abuja Faroyo, Kunga wana si Mohammed Mahadi Shehu, mu bincike shi, an yi report a kan shi cewa yana maganganu wanda ba gaskiya ba kan gwamna na Katsina state da su secretary to the government da yawancin mutanen executive na shi gwamnati. So shi ne an reporting case din ma aji. So da aji ya gama mutanensa sun investigate an gan cewa maganganu wanda ya yi ba na gaskiya ba ne, shi ne a sa muka kawo shi na court a yau din. So da mun kawo shi a court ya riga ya ji magana, ya fara ji magana yau. So an daga zuwa Juma'a magana bail na shi, because shi lawyer na shi bai kawo application na bail na shi ba tukuna. So shi ne court ya ba shi dama yi application for bail. So ranar Juma'a shi ne za mu yi magana application na bail na shi.
Amma laifin da ake zargin ya aikata za a iya ba da beli?
Laifin ka gani ba dama judge ne shine dai yana da dama ya ba da bail ko kuwa ya hana bail. Ba wai dole sai an ba shi bail, amma judge ne shi yana da izini ya ba ko kuwa ya hana. Abin da zama shi na kenan, because dokan da ma an kawo shi a court na ba ya kamata ba wai lalle sai an ba da bail ba ne. Kun karanta da kan that is cyber crime act. Da kan yanzu wanda in ka yi magana kan ma mutum ba gaskiya ba, in an zo tabbata cewa magana ba gaskiya ba, kuma zai kama kuma shaida zai kama ka, shi na sa ka kawo shi.
Babar, counsel for the first defendant in the charge that was just had by the Federal High Court, Katsina Judicial Division today.
Okay, sir, two issues that feature prominently in your argument. The issue of contempt on the part of the prosecution, and then the file of motion that you filed. Motion on notice, that you filed, challenging the jurisdiction. Would you like to comment on this issue?
Yes, we were of the opinion that in view of the order earlier made by the Abuja Judicial Division of this Honorable Court on the first day of March, granting bail to the first defendant, and in fact with a warrant for release signed by the Honorable Judge of the Court in Abuja, specifically Honorable Justice Taiwo ordered the release of the first defendant after he has met all the bail conditions. We were of the opinion that the refusal, deliberate refusal by the complainant, the IGP, Honorable Superintendent General of Police, to release the first defendant in compliance with that order of the court amounted to flagrant disobedience of a valid order of court, which is still subsisting up till now. And we rely on the tried position of law that a party in disobedience of court order cannot be heard or indulged by the court. And the principle is that the Federal High Court is one. And so the complainant, by disobeying that order of the court made by in Abuja, is actually disobeying the order of this court. So we wanted Melo to give effect to that principle by refusing to indulge them, by refusing to hear the prosecution, the Inspector General of Police, to arraign the first defendant until they comply with that order. Unfortunately, we were not able to persuade Milord in that direction, because Milord was of the opinion, and we are bound by Milord's opinion, which is the overriding one, that today's business was for arraignment, and we could not raise any objection. But our objection was that yes, it's for arraignment, but because they are in disobedience, we cannot arraign.
Are you for photo?
Let me tell you the motion on notice. We filed a motion on notice today. Don't forget that it was only on Saturday, but we're waiting to be released in Abuja, that they ferried the first defendant to Katsina, and we're only able to move from Abuja, his lawyers, to Katsina only last night. And we were able to work overnight and file a motion on notice this morning, challenging the competence of the charge, the jurisdiction of the court to entertain it, based primarily on issue of abuse, in the sense that as we speak, there are at least 3 other criminal charges based on the same set of facts upon which the first defendant is charged before this court against the first defendant. And the law is that you cannot file multiple charges, more than one charge against a defendant based on the same facts and circumstances in different courts. So our objection basically is that the charge as constituted before this court is an abuse of court process. We have filed a motion. There are other grounds. We have not been given a date for the hearing of that motion, because we just filed it today, and the complainant are entitled to be given time to file their response. As to whether I'm satisfied with the way the proceedings are going, well, the proceedings went the way they should go in the law court. Yeah. The complainant make their case, the defendants make their case, we respond, and we leave the court to rule. Are we happy with the rulings of the court? Of course, we are disappointed that we are not be released on bail, and we are disappointed that we have to wait for a longer time to come and try our luck on our application for bail. We would have been happier if we were released on bail, but the proceedings went the way they should go. The court has heard both sides, and the court has ruled and decided.
Your client was still spotted by crutches. What's the matter?
My client has been ill for quite some time. When the police arrested my client, first arrested him in November 2020 and detained him for 11 days in their detention, he was bitten by a snake in their detention, and that has affected his breathing. It has caused some respiratory problem. And even while the police released him on bail, sequel to an order made by the FCT High Court in December last year, he took ill, and we have communicated, told the police before now of his status. And of course, having been in detention for a prolonged time now, since the 16th of February 2021, in defiance of the court order releasing on bail, sleeping on bare floor, particularly here in Katsina, has obviously aggravated his health situation.